Hello, good afternoon, good evening, good morning, depending on the time that you're watching this. My name is Attorney Rosario Olivas Quinto, and I would like to discuss the rules on default. Ang gagamitin ko ngayon, class, ay yung aking handout na prepare on this topic. If you are interested in getting a copy of this handout, lagay nyo lang sa comment box so that I can send you a copy by email. Ilagay nyo na rin yung email address ninyo. So the rules on default are found in Rule 9, Section 3 of the 2019 amendments to the Rules on Civil Procedure. Diba alam natin na if the plaintiff files a complaint, the defendant is required to file an answer. Generally, the period for filing an answer is 30 days within 30 days from service of summons, and that is according to Rule 11, Section 1. Now, the court may provide for a different period, but there is another period provided by the rules of court, and that is within 60 days from service of summons. This refers to a situation when the defendant is a foreign, private, juridical entity, and the summons was served on our government representative or official designated by law to receive the summons. So if the defendant does not file an answer within 30 days, within 60 days, or within the period set by the court, pwedeng mag-file ng motion to declare in default ang plaintiff. Note, the court cannot issue an order of default motu proprio. Dapat palaging may motion na ipafile ang plaintiff. So, ano ang mga requirements bago makapag-issue ang court ng order declaring the defendant in default? Number 1, the plaintiff must file a motion. So necessarily, it has to be a written motion. And this is considered one of the litigious motions mentioned in Rule 15 of the Rules of Court. Number 2, the motion must be accompanied with notice to the defendant. Hindi ito notice of hearing. It is a notice to the defendant. In other words, the defendant must be furnished with a copy of the motion. Bakit kailangan may notice? Because under Rule 15, Section 5, Number 13, as I just mentioned, a motion to declare the defendant in default is a litigious motion. Ang ibig sabihin nito, may opportunity ang defendant to file an opposition, and the period for doing that is within 5 days from receipt of the motion. So hindi na kailangan mag-issue ang court ng order directing the defendant to file an opposition. Under the new rules, Rule 15, automatic, may 5-day period ang defendant to file an opposition. Now, the court can opt to set the motion for hearing if it likes, but that is discretionary upon the court. And the court will have 15 days within which to resolve the motion to declare the defendant in default. Ano yung counting ng 15 days? Within 15 days from the filing of the opposition by the defendant. Pero kung hindi nag-file ng opposition ang defendant, ang counting will be upon expiration of the 5-day period for filing an opposition. Now, number 3, the motion must also prove that the defendant failed to file an answer within the required period. So anong klaseng ebidensya ang kailangang ipresenta ng plaintiff in order to prove this? Well, he must attach a copy of the summons showing that the summons was received by the defendant on a given date, and that despite the lapse of the period provided by the rules, hindi pa siya nagfa-file ng answer, which will be apparent from the records of the case. Now, when the court is satisfied that these requirements are present, it will issue an order declaring the defendant in default. Ano ngayon ang mangyayari? Anong gagawin ng court? The court can do one of two things under Section 3 of Rule 9. Number 1, pwede nang mag-decide yung court based on the complaint and the documents attached to the complaint. Number 2, the court may require the plaintiff to present evidence ex parte, meaning without the participation of the defendant. Okay? In my experience as a litigation attorney for more than 30 years, palaging nagre-require ang court ng evidence presentation by the plaintiff ex parte. Now, the rules provide that the reception of evidence may be delegated by the judge to the clerk of court. But note, what is delegated is only the reception of evidence, not decision-making, because the judge will be the one to render the decision. So, when the court issues an order of default, what does this mean for the defendant? The defendant will not be allowed to participate in the trial, but he is entitled to receive notices of the proceedings. So, alam niya kung anong nangyayari sa case. Are there remedies that the defendant can avail of in default situations? Yes. Now, the remedies depend on the stage of the proceedings in which the defendant learns that he has been declared in default or whether a default judgment has already been issued. So, ito, in-enumerate ko yung mga remedies. Number 1, if the defendant receives the motion to declare him in default, so motion pa lang, he can, of course, file an opposition within 5 days from receipt according to the rule on litigious motions. Number 2, kung ang natanggap niya order of default, pero wala pang judgment, he can file a motion to lift the order of default, and there are 3 requirements. Number 1, the motion must be under oath. Number 2, the defendant must show that his failure to file the answer is due to fraud, accident, mistake, or excusable negligence. And number 3, that he has a meritorious defense, which he must prove through an affidavit of merit. Now, the affidavit of merit, it is not enough for it to state that he has a meritorious defense. He must point out in the affidavit what that meritorious defense is. So it must contain factual allegations. Now, the judge may set aside the default order on just terms. Number 3, if there is already a decision and it is still within the 15-day period to appeal, all right, so there are remedies available to the defendant. Number 1, he may file a motion for a new trial within the 15-day period from receipt of the decision on the ground of fraud, accident, mistake, or excusable neglect. So itong number 4, dapat number 3, letter A yan. And then, next remedy within the 15-day period is he can file a motion for reconsideration if his ground is that the decision is not supported by the evidence, the decision is contrary to law, or the award of damages is excessive. And the third remedy that he can file within the appeal period is, of course, a notice of appeal. Now, suppose he received the decision beyond the 15-day period to file an appeal, he can file a petition for relief from judgment under Rule 38 as long as it is within the necessary period. Ano yung period na yon? It must be within 60 days from notice and within 6 months from entry of judgment. Next, in extraordinary cases, he can file an action to annul the decision under Rule 47 by filing a case with the Court of Appeals invoking extrinsic fraud or lack of jurisdiction as grounds. Now, if the order of default was issued with grave abuse of discretion amounting to lack or excessive jurisdiction, note here, I'm not talking of the judgment. I'm talking of the order of default, all right, which was issued with grave abuse of discretion. The defendant can file a petition for certiorari under Rule 65 within 60 days from receipt of the default judgment or within 60 days from receipt of the order of default. Okay? Now, note that you have to distinguish between a default order and a default judgment. A default order is issued pursuant to the plaintiff's motion before evidence is received. A default judgment is issued after the court considers the plaintiff's evidence. And note also that these rules apply to permissive counterclaims, in which the plaintiff becomes the defendant on the counterclaim and is required to file an answer within the reglementary period. And it also applies to third-party complaints. Suppose there are several defendants, some of whom file an answer while others are in default. Anong gagawin ng court? The court will try the case based on all the answers filed by the defendants and render judgment upon the evidence presented. If a defendant has been declared in default and the plaintiff was able to present evidence showing that he is entitled to an award much more than what is prayed for in the complaint, can the judge grant such an award? The answer is no, because under the rules, a judgment rendered against a party in default shall not exceed the amount or be different in kind from that prayed for, nor award unliquidated damages. Are there cases when defaults are not allowed? Yes. And these are cases involving marriage. So number one, actions for annulment of marriage. Number two, actions for declaration of nullity of marriage. And number three, actions for legal separation. In these cases, if the defendant fails to file an answer, the court will order the Solicitor General or the public prosecutor whom he deputized to investigate whether there is a collusion between the parties. If the court finds that there is a collusion, it will dismiss the petition. But if there is no collusion, trial will be held and the OSG or public prosecutor shall intervene for the state in order to see to it that the evidence submitted is not fabricated. So these are the rules that you have to remember concerning defaults.